All of these questions we are discussing here on CBS 2 as we have received the decision from the High Court that the central New York State law that places strict limits on handguns has been overturned. CBS News national and legal correspondent Jan Crawford joins us now from Washington, D.C. with reaction to all of this. Jan.
Well, I mean, I think it's important to first point out that what this ruling does not do. It focuses on the New York law and a handful of others that are just like it, that require people, if they want to get a concealed permit, to show that they have that special need for it, that there's an extra reason that they need that concealed carry permit instead of just wanting to carry one for self-defense. And the court, in its 6-3 ruling written by Justice Clarence Thomas, said that that violates the Second Amendment. The core reason for the Second Amendment is to provide law-abiding citizens with the ability to carry a gun for self-defense. And of course, in 2008, for the first time, the court said the Second Amendment protects your ability to have a handgun in your home for self-defense. Today, the court is taking that next step and saying you can also carry it outside your home for self-defense. In states like New York, including New Jersey, California, Maryland has a law like that. Illinois used to until a lower court struck it down. Some of those more populous states, those states that require that extra hoop that you have to jump through, that's unconstitutional. But the court and the justices, the conservative justices, writing separately, took great pains to say what the court is not doing and what this ruling does not say. It's imposing no limits on common sense gun regulation. In fact, the court has said that the right to own a gun, the Second Amendment right, that is not unlimited right. And so that has nothing to do with, for example, potentially some of the gun legislation that we're hearing now. The court says this would not prevent states from passing permit laws. They just can't require that extra hoop that New York had. And one of the justices, Justice Samuel Alito, in his separate opinion, pointed out that this law was on the book in New York. This law has been on the books until today when the court struck it down, and it did not stop the massacre in Buffalo. This is about, because of the ubiquity of guns, being able to give law-abiding citizens the right to go get a permit and carry a gun for self-defense if they believe it's necessary.
And now many are concerned, though, that this may be just the beginning. Are other restrictions now going to be called into question, including what we've been talking about in regard to those stricter limits?
That's the next step. And I think anytime the court rules on the Second Amendment, because it's been so rare, this is only the second case since the court decided in 2008 that the Second Amendment protected your individual right to own a gun. This is only the second time they've revisited it, so of course this is a major case. One of the things I think that's going to be really interesting is to see to what extent states could try to prohibit concealed carry in some of those sensitive places. That came up at the oral argument. Some of the conservative justices thought it was really not necessary to get into that right now, and Heller itself suggested those laws would still be okay, as would other licensing laws, various restrictions on the type of guns, any time that you could restrict someone from, say, felons and mentally ill from owning a gun. The court's cases on the Second Amendment taken together suggest that all of those laws are still okay.
Jan, you've been mentioning the oral arguments, and one of those was the question as to whether there should be a determination in, density of population. Should it be different when you consider New York City versus Wyoming, maybe, Manhattan versus upstate New York? But in the end, it seems like they did not take that into consideration when it came down to this ruling.
Absolutely not. And the reason that, you see some of these states, and of course, like I said, 43 states don't have this kind of extra hoop that you have to jump through. But the states that do are some of the more populated ones, like California, like New York, like New Jersey, like Illinois, until that one got struck down, of course. But that's something that the justices said. If you're walking, and this was some of the lower court rulings too, if you're walking in a high-density area late at night after you've gotten off your job, then you may have more of a need for self-defense than if you're sitting up in your 35-floor high-rise in your home, where the court has already said you do have a right for self-defense. So states have to be, or at least the 7 states that weren't, the court said, more sensitive to that and the rights of the individual to protect themselves with a gun if they're outside their house too. But, in terms of the rural area versus, it's interesting if you look at the different state laws. Vermont has the most wide open, no restrictions, but of course it's much more rural, and we've seen some of these more populated states pass the more restrictive laws. Not all of them, of course. Many of them are in the South. I mean, Florida doesn't have it. Texas doesn't have it. Those have big cities, too. But the point is, are these restrictions doing anything to stop the mass violence? And the conservative justices in this ruling and in subsequent opinions that they have attached to it say that that's not the problem. You know, the Buffalo shooter didn't go try to get a permit. You know, he just said, I'm going. And so this case will have no impact on stopping any of that.
Jan Crawford. Jan, thank you very much for taking time to talk to us this morning.